everyone, and thank you for joining us today. My name is Michaela Vrazdova, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time and we will talk about the E-1 visa, and we will go over the E-1 visa requirements and whether you could qualify for an E-1 visa. So a few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals and companies pursuing various types of visas and green cards. So we can assist you with family-based, employment-based, and investment-based visas and green cards. And we regularly process a high number of both E-1 and E-2 visas. So we will continue to have this webinar series, and we will do at least 2 webinars a month on different visa topics. At the end of this webinar, we'll send you out a few things. So we'll send you the PowerPoint I will be using during this webinar, and we will also send you our comprehensive E-1 visa guide that goes over the E-1 visa requirements in detail. We will also send you a link where you can sign up for additional webinars we'll have in the future, and we will also send you a link where this webinar will be recorded. Finally, this webinar will be made available on our YouTube channel, and we encourage you to subscribe to our YouTube channel as we often post new videos on different immigration topics. And finally, we'll send you a link where you can set up a consultation if you would like to discuss your particular case with one of our attorneys. Finally, if you have any questions as I go through the presentation, please put it in the chat box or in the Q&A box, and I will get to the questions at the end. Perfect. So why don't we get started? So the E-1 visa is a non-immigrant visa, either for a person or a company who is a trader and that engage in a substantial international trade between the US and their home country. So what are the E-1 visa requirements? So first, and I would say kind of like the most important requirement is that you are a national of E-1 visa treaty country. So not all countries in the world, sign an E-1 visa treaty with the United States. So first, you would want to check if your country has, such a treaty with the United States. There are many countries, throughout the world that are E-1 visa treaty countries. For example, countries in Europe, Latin America, Africa, Asia. But you would want to double check, if you meet this requirement. And what is important here is also that, what the government looks at is, are you a national of this E-1 visa treaty country, and the country of birth, for E-1 visa is not relevant. So, we have many clients who were born, for example, in China or India, that are unfortunately not E-1 visa treaty countries, but later in their life, they got another citizenship, like, for example, citizenship of, Canada, Italy, Mexico, and these countries are all E-1 visa treaty countries. And as long as you are, a national of one of the countries, of one of the E-1 visa treaty countries, you would be able to meet this requirement, regardless of, which country you were born in. The second requirement is that, as it, it's clear from the name of the visa, is that there must be a trade between your home country and the US. So what is trade? So the trade is defined as an exchange of qualifying commodities. The exchange must be traceable and identifiable, and the trade must be already existing at the time you are applying for an E-1 visa. And we'll go over all of these all of these requirements in more detail later in the presentation. But the important thing is that the trade between your home country and the United States must be already existing at the time you are applying for an E-1 visa. So, let's say, for example, that you are where, you know, you just kind of like set up a company in your home country and the company is just, you know, like hasn't even started, you know, trading yet, you know, the E-1 visa would at that point not be an option for you, because the government, for the E-1 visa, they already want to see kind of like an established trade before they give you the visa. So another requirement is that the trade must be substantial, and we'll go over this on one of the next slides. And the trade must be also international. So what does international mean? So international means that at least 50% of the company's international trade is with the United States. So the government wants to see that, you know, at least 50% or more, like the majority of your international trade is with the United States. Another requirement is that, you know, the E-1 visa applicant is coming to the US to engage in this, you know, in the E-1 visa trade. So, you know, if your plan is to kind of come to the US and then kind of, you know, like retire here and just kind of, you know, you want E-1 visa for this purpose, you know, that would not be possible, unfortunately, because, you know, for the E-1 visa, we would have to show that you'll be kind of actively involved in kind of like managing the company. You know, you would either have like an executive or managerial role, and you will basically be running the company in the United States. And the final requirement is that you must have intent to return to your home country after the visa expires. So, you know, the E-1 visa is a non-immigrant visa. So, you know, your plan when you are kind of like applying for the E-1 visa should not be to kind of like, you know, like move to the US, like, and kind of like live here indefinitely. With that being said, you know, what the government generally wants to see, you know, to show that you have a non-immigrant intent for the E-1 visa. Usually all they want to see is kind of like your signed declaration that says that once the E-1 visa expires, you will return to your home country. So the standard, you know, is much, much lower than, for example, when you are applying for a B visa, where you have to submit detailed documents that you have ties to your home country. You know, you keep residence there and all of that. For E-1 visa, as I mentioned, it's still a non-immigrant visa, but the standard is usually quite, you know, quite low, and all the government wants to see is that signed declaration that you do intend to return to your home country. So, you know, what can qualify as trade? So, you know, basically any item that is commonly traded in international commerce can qualify as trade. So, for example, you know, goods, you know, if your company is, for example, selling, you know, fabrics, you know, materials, clothes, jewelry, or, you know, basically like any goods, you know, all of that can qualify as items of trade, but also services can qualify as items of trade. So, for example, if your company, you know, like let's say that you have a company in your home country that is providing consulting services to US clients, you know, you could also get an E-1 visa, you know, for this arrangement, because services can also, you know, qualify as items of trade. So how do you, you know, like how do you prove to the government that there is this ongoing international trade between your home country and the United States? So the important thing to note is that you should always kind of check the requirements of the consulate where you will be applying for an E-1 visa, just because, you know, different consulates wants to see different things. But generally, you know, what you would want to submit are trade spreadsheets. You know, we usually submit them for at least 2 or 3 most recent years. And these spreadsheets would basically detail, like, you know, like who were your clients, for example, in 2022, like what was the nationality of these clients. And, you know, it would kind of like list all the clients you had. It would list kind of like all the transactions you did with all of these clients. in the past year. And you know, what you would want to show is that to meet that international requirement is that at least 50% of that international trade is with the US. You know, you could also submit, sometimes the consults want to see like excerpt of invoices you issued to your clients. You could also submit bills of lading, like if you are importing some goods to the United States. You could submit bank statements that show, you know, incoming payments from clients. DHS custom documents, again, if you're kind of importing something to the US. Or you could submit your company's tax returns, again, just kind of showing, you know, like the revenue you earned in the past years. So now let's discuss the substantiality requirement in more detail. So, you know, like how much trade is enough? Like what does the government want to see? So there is no like set amount or like set, you know, like in set amount of trade that would be sufficient in the regulation. You know, the government, when they kind of like look at, you know, what is substantial trade, they want to see that there is this continuous flow of trade between your home country and the United States. So first, you know, they look at, you know, like how many clients you have. So for example, if you have a company in your home country and you only have one client in the US, you know, that would not be sufficient. So, you know, the first thing they kind of like look at is how many clients you have. So you would want to see that you have several clients in the US. Then they look at, you know, like how many transactions you did with each of these clients in the past couple months or past couple years. So you would want to see, you know, again, you wouldn't want to just kind of show that you only issued, you know, like one invoice to each client past year. You would, you know, what they want to see is that the continuity. So they want to see that, you know, there were like, you know, like numerous invoices issued to each of the clients in the past couple months or past couple years. You know, the kind of like the regulations specifically say, like, let's say that you had like, let's say 5 US clients, and you know, to like one of them you issued invoice for like $5 million. Like even if the invoice is for such a large amount, it would like never be sufficient, because they do want to see that, you know, like you were like trading with the clients like throughout the years. So they do want to see kind of like those like numerous transactions over the past couple months or past couple of years. And then they will also look at value of, you know, like of each of these transactions. So you know, the value, I would say, is important, but even, you know, like let's say that you are concerned, like, okay, like these invoices were for like smaller amounts, you know, it's, you know, it still can be fine, because, you know, even smaller companies that, you know, the revenue is not that high, they can still qualify for an E-1 visa. So I would say that the number of clients, the number of transactions are going to be the most important. And then, you know, the government will also look at the kind of like the amount of each invoice. So so how long, you know, like does the trade have to last before you can apply for an E-1 visa? So again, this is kind of not set in the, you know, in the regulations, but generally we recommend that the trade has been ongoing for at least 6 months before you know, before you apply for an E-1 visa. And we generally recommend that the trade exceeds 250,000 per year with the US clients. Okay, so I think we went over all of these. And one other thing just to keep in mind is that, you know, the trade has to remain substantial even after you get the E-1 visa. So this is important thing to keep in mind, especially, if you plan to renew the E-1 visa, because let's say that, the trade numbers were great, but then you come to the US and the trade suddenly like just decreases substantially. That could definitely come up at the renewal stage. So, you want to kind of show that the trade remains substantial, even after the E-1 visa was granted. Okay, so mass trade already exists at the time I'm applying for an E-1 visa. So yes, we as we discussed, we generally, yes, the trade already has to be existing. I would say one exception would be that, like let's say that the trade is kind of like on the lower side. So like let's say that you just started, the foreign company just kind of started trading with the US in like January this year. It's August, and the trade has only been around like $100,000, like with all clients. The exception would be if you could submit binding agreements for kind of like future work with US clients. So like let's say that you would be able to submit 3-4 binding agreements with US clients that have a start date I don't know, in like October, November, and the trade with each of these clients is going to be $50,000 to $100,000. So I would say in that case we could still go ahead and kind of like submit the E-1 visa application. But as a general kind of like rule of thumb, we recommend that the trade has been ongoing for at least 6 months, and the trade amount per year is at least $250,000. Now, how much trade has to be between the US and your home country? So at least 50% of your international trade must be between the US and your home country. So let's look at this example. So let's say that you have, for example, a company in Spain that manufactures, glass and exports it to other countries in the world and also within Spain. And so, so sales within Spain are $100,000, sales with the US are $500,000, and sales to China are $500,000. So, for the analysis, whether, the majority of the trade is with the US, what we look at is only the international trade. So we would kind of disregard all the trade that is going on within Spain. So we wouldn't look at that. And then we would only look at the sales to the US, which are $500,000, sales to China, $500,000. So in this case, the company would still meet the requirement that at least 50% of the trade is with the US, just because the domestic trade with the Spain would be disregarded. Okay, so should you apply for an E-1 visa at a consulate, or should you do a change of status in the United States? So generally, we recommend that you apply for an E-1 visa at a consulate in your home country, just because the visa will give you flexibility to travel in and out of the United States, and it just kind of gives you more flexibility. And I would say in most cases the visa would be issued for kind of like a longer period of time than the change of status approval from USCIS. So I would say that is kind of like the main difference between these two applications, is that if you are applying for an E-1 visa at a consulate, the visa is a document that kind of that allows you to enter the United States. If you apply for a change of status with USCIS, the approval would be granted for 2 years. But that would just give you an ability to stay in the United States for 2 years. But if you leave within the 2-year period, then you would need to apply for the visa at the consulate anyway. So, I would say like most of our clients prefer, to kind of apply for the visa, as they kind of need to travel, often. The advantage of applying with USCIS is that, you can apply for a premium processing. This means that you can pay additional fee of $2,500. And the government in this case will take a decision on your case within 15 days. So, I would say for people, if you are in the United States on some other, visa status, not on ESTA, because you wouldn't be able to do change of status from ESTA. But if you are here, for example, as a B1 business visitor or on an L1 visa or F1 visa, you could do the change of status. And I would say the main advantage is that, if you pay for the premium processing, you could have a decision in 15 days. On the other hand, the kind of like the wait times at consulates are usually, much longer than that. So normally, from the time you submit the E-1 visa application, you would have to wait like several weeks or I would say like at least like 2 months at minimum for an interview appointment. At some consulates, it's just taking much longer than that. So I would say like the main advantage of doing the change of status is that you can just get an approval quickly. And once you get the approval, you can just kind of start, like managing and running the company from the US. Perfect. So let's go over some, like recent E-1 visa developments and adjudication trends. So, like let's say that, in the last couple of like you are approaching to renew your E-1 visa and you have not been living in the US during COVID. You have been kind of mostly living in your home country. Like, is this going to be an issue for your E-1 visa renewal? So, the answer is no. So there is no requirement that once you get the E-1 visa, you kind of reside in the US for a majority of your time. I would say, majority of our clients, like once they get the visa, they kind of usually spend most of their time in the US. But we also have some clients that just kind of, that they get the E-1 visa, they live in their home country, and they just kind of come a couple times a year, stay for a couple of weeks to kind of like, check on the business, and then they go back. Or even if you get the E-1 visa and, like you just kind of like live in your home country, like you haven't been to the US in the past, like 1-2 years at all, like it's not going to be an issue just because there is no residency requirement for the E-1 visa. So now, like what happens if you are going to, like renew your E-1 visa and the trade has decreased during COVID, or you lost some of your clients during COVID? Like, will this kind of like be an issue at the renewal stage? Like we have been obviously like seeing this a lot. I would say like the majority of the, of all businesses have been impacted to some extent, like during COVID. Like as long as, let's say that in 2020, 2021, the trade has kind of like dropped. But as long as at some point it kind of like picked up again, we would just kind of describe it, that the business has been impacted by COVID, and the consulates are usually kind of like pretty understanding, as long as it kind of like picked up at some point. So let's discuss, whether you have to have a business plan, employees, or and business entity for an E-1 visa. So business plan, submitting a business plan is not required for an E-1 visa, but it may be in some cases. So I would say that, if the trade is kind of like on the lower side, submitting a business plan would definitely be helpful. In the business plan, you could just kind of explain, what the company will be selling, like what goods or services the company will be selling, how do you plan to market the company's products or services, and kind of include, like financial projections for the next 5 years. So, in that case, the consulate would see that, okay, like the trade is on the lower side, but the company or you have some plan in mind how to kind of increase it. So, in some cases, we do recommend that a business plan is submitted with the application. Now, regarding hiring employees, so it is not kind of like explicitly required, like that the E-1 company hires employees in the US, but it's always helpful. So let's say that that you hire like 2, 3, 4 employees in the US, like we would definitely like mention it in the renewal application, or if you already have them in the kind of like in the initial application. But it's not required like how it is for the E2 visa, because like if you don't have employees when you are kind of renewing your E2 visa, it's almost certainly going to be denied. Like if you have no employees when you are renewing your E1 visa, it can still be approved. But if you do have some, it's definitely going to be helpful. So do you have to have a business entity if you are applying for an E1 visa? So it's not required that you have an entity in your home country or in the United States, to apply for an E1 visa. The treaty trader can be an individual, partnership, joint venture, company, corporation, so it's not necessary. But I will say, like in some cases it may be helpful to especially like let's say that you have a foreign entity and that foreign entity is trading with the US clients, and then once you come to the US, it may be helpful to kind of set up like a branch or an entity just for like tax liability, employment purposes, but again it's not required. So what are some common reasons for E1 visa denial? So, I would say like the most common reason would be that the trade amount is just too low. So let's say that, the company was just kind of set up in 2022 or 2021, and the trade, in the past like 2 years has always been only around like $50,000 to $60,000. That's just going to be too low. So, that would be kind of like the first reason. The second reason is that you only have kind of like very little amount of clients. So like, let's say that you only have like 1, 2, 3 clients in the US, it just, the number just may be too low. So, kind of like the more clients you have, the better. Another reason can be that there is just not enough transactions. So like, let's say that, you like in this case, like you do have like, 15 clients in the US, but to each of the clients, you only kind of issued, there was only 1 transaction in the past year with each of them. So there was only like 1 invoice issued to each of them, then the government may just conclude that the trade, there is not that continuity they want to see in the trade. Then the next reason can be, that the less than 50% of the international trade is with the US. So you would want to kind of like always keep it above the 50%. And here it's also important to just kind of keep in mind that, the 50% international trade, it also kind of like has to continue after the E1 visa is granted. So, that's something you should always kind of like keep in mind. And then another reason can be that, the trade is just not yet existing at the time of the E1 visa application, and you don't have, any binding contract. So, in this case, you just wouldn't meet the E1 visa requirements. I will say, like, let's say, for example, you set up a company in the US and you are kind of like looking for clients in the US and want to kind of like explore the US market more and like meet with some of the clients in person. Coming as a B1 business visitor, either on your B1 visa or on an ESTA as a business visitor may be an option. So this would kind of give you the opportunity to come, like meet with the clients. Like you wouldn't be able to kind of like work in the US, but you would be able to kind of like attend the meetings, and then, that may give you a ability to kind of like sign contracts. And then once you go back to your home country, the trade may kind of like pick up, and, in a couple of months, you could be able to apply for the E1 visa. So one option, if there is no trade yet, you don't have any contract, is to come to the US, as a business visitor, either on a B1 visa or on an ESTA. So, how do you renew your E-1 visa? So in the renewal application, you will have to show that you are still meeting all the kind of requirements we just went over. So, the trade must still be substantial. So evidence you would be submitting are, for example, the company's tax returns since the year the E-1 visa was initially granted. Trades, kind of like updated trade spreadsheets for the last couple of years, invoices, you have been issuing to clients, or the company's bank statements. And you would also want to show that, since the E-1 visa was kind of initially granted, at least 50% of the international trade was always between your home country and the US. And as I mentioned in the beginning, it's important to kind of like check the website of the consulate, like where you will be renewing the E-1 visa, just because, like some consulates only want to see like the invoices or like the DHS import documents, like, the different consulates like want to see different things. So you would just want to check the website to see like what kind of evidence you have to submit. Perfect. So I don't think we have any questions. So thank you everyone again for joining us today, and we'll send you out the PowerPoint and the E-1 visa guide and all the information I mentioned in the beginning. Okay, thank you. Bye.